Hi, I'm Jon Velie, CEO of OnlineVisas, and welcome to another issue of Voice of Immigration. If you're watching this on YouTube, please like and subscribe and turn on your notifications if you want to keep up to date. If you're watching this on Facebook, thanks a lot. Like, share, and stay tuned for more things. We're going to talk about three things today. Number one, a new memo from Immigration was just issued June 17, 2020, on rescission of the Policy Memorandum. We'll get into that. Number two thing we're going to talk about, the Supreme Court just came down on DACA. And number three, the new executive order should be dropping any day. And we think maybe just in time for Trump's first rally, which will be in Tulsa, Oklahoma, my home state, with all the things around that. We think that dropping that will end up being political banter. So let's dig into this. So the policy memorandum is rescission of two other policy memorandum. Now, this is not a surprise. So let me give you the background on it. So in March, in a case called ITServe Alliance versus the Secretary of Homeland Security, the D.C. court ruled very strongly that USCIS had violated its own policies in utilizing two memorandum, right? So the one memorandum was the 2010 determining employer-employee relationships for adjudication of H-1B petitions. And the second one was the contracts and itineraries requirement for H-1B petitions involving third-party work sites. And that was from February 22nd, 2018. Now, these policies had been wreaking havoc on H-1Bs, in particular, staffing companies who were placing their employees at third-party locations. So, not surprised because there was a settlement following that case that came down a few weeks ago. And this is a policy memorandum saying that those memorandums should not be used. How immigration works is that the adjudicators have these memorandums. They sort of have a checklist, right? And so they had to rescind this, or the adjudicators would be looking at this. And the timing of that is interesting on a couple levels. So here we are mid-June. The last day of June is the last day you can put in the H-1B visas under the cap. The cap lottery was in March, and then they issued the visas that could be applied under the cap, and then the cap was to do this. So they needed to do this. Now, the ink's not even going to be dry before the president drops a new executive order, which will deal with the H-1B, and we'll talk about that in a little bit. Also, stay tuned, because we're going to do a webinar, we think on June 25th, but stay tuned on that. Check with our YouTube channel, our Facebook page, and OnlineVisas.com for news on that. So the webinar we're going to do and other videos we're going to do are going to be what does the executive order do, and what's still permitted and what's not permitted under it. So stay tuned for that. So meanwhile, I'm going to give you this. So what this says is that a couple of questions. So I'm going to read the questions to you and give you some feedback. So question number one, or A under the employer-employee relationship, number one is, should an officer consider an H-1B petitioner and an H-1B beneficiary to have an employer-employee relationship if they meet only one of the hire, fire, supervise, or otherwise control of the work factors under 8 CFR 214.2 H42? So the answer is the officer should apply the existing regulatory definition in assessing whether employer and beneficiary have employer-employee relationship. The officer should consider whether the petitioner has established that it meets at least one of the hire, fire, supervise, or otherwise control work of factors with respect to the beneficiary. H-1B petitioners are required to submit an LCA, it's a labor condition application, and a copy of any written contracts between the beneficiary and the petitioner, or a summary of terms of the oral agreement if a written contract does not exist. Depending on the contract and such documentation, it may establish the employer-employee relationship. The officer may not apply the prior rescinded guidance. Okay, so what does that mean? So it asks, should they meet only one? And it says, establish that it meets at least one, which under that language is at least one means one or more. So is it one or more? So the cases were very strong that they only had to meet one, right? So I think if you utilize, when you're adjudicating this, the ITServe Alliance case, then it's one. At least one's interesting because that's a little fuzzy. But they are saying they can't use the other ones where they kind of used, all of them, right? So a good win there, and although some funny language. Okay, question number 2. Must the H-1B petitioner establish that the employment exists at the time of filing? A bona fide job offer must exist at the time of filing. So it's yes, right? The petitioner is required to attest under penalty of perjury on the H-1B petition and LCA that all the information contained in the petition and supporting documents is complete, true, and correct. The petitioner has the burden of proof to establish the employment exists at the time of filing and will employ the beneficiary in a specially occupation. If the petitioner attestations and supporting documents meet this standard, then the officer should not request additional evidence and should approve the petition, provided all other eligibility requirements are met by preponderance of evidence. If the officer finds that a petitioner is not established by a preponderance of evidence, statutory or regulatory eligibility for the classification at the time of filing, the officer should articulate that basis in denying the H-1B. To make this determination, the officer should apply statutory and regulatory requirements, excluding the itinerary requirement, binding court precedent, AAO adopted in proceedings, so on and so forth. So what does that mean? So you can't lie. Yeah, there has to be a job, but and look, this is why these things started in the first place. There were companies that were going out and you always applied for these H-1Bs 6 months ahead. So on the now it's March to do the lottery filing, but April 1st is the earliest you could file the actual petition. So on April 1st, companies were going out and asking for large numbers of visas and hoping they would find the work by October 1st. So you can't do that. Don't do that. However, what it's saying is you make a penalty under perjury that you have this work, and that's all they're going to look at. So, best practices, don't lie. Have the work and do it that way. But immigration is precluding itself from digging in the way it did on RFEs and denials before. Okay, so number B, or letter B, contracts. Question 1, under contracts. Should an officer request the chain of contracts or legal agreements between the H-1B petitioner and third parties, including the ultimate end client letter and immediate vendors, to assess the employer-employer relationship or non-speculative employment and especially occupation work availability? This is what they used to do. Should the officer request a chain of contracts between them? In support of the petition, an H-1B petitioner is not required by existing regulation to submit contracts or legal agreements between the petitioner and third parties. However, the petitioner must demonstrate eligibility for the benefit sought. In assessing whether an employee and a beneficiary have or will have an employer-employee relationship, the officer may consider any evidence provided by the petitioner, including chain of contracts or legal agreements between the petitioner and third parties. Further, if a petitioner provides contracts or legal agreements, the officer is not precluded from evaluating the evidence and adjudication or other eligibility. Okay, so that's interesting. No, you don't have to do it. You can do it, but if you do it, and they don't think it looks very good, they can ask for other eligibility. Strategy there. Okay, so we'll marinate on that a little bit and tune in for how to get visas after the Trump executive order on how that may come into play. So that's a pretty interesting thing. So do you put it in and hope you get it, but because you don't have to, but if you do put it in, is that going to open the RFE? Pretty interesting question, right? So we'll see. Playing chess with these guys, right? Letter C, non-speculative specialty occupation work. Number 1, should an officer require evidence of day-to-day assignments to establish the availability of specialty occupation work? Answer. The officers should review the position as described by the H-1B petitioner to determine if the petition has met its burden of proof to establish the beneficiary will be employed in a specialty occupation. While evidence of the specific day-to-day assignments is not required to establish that the position is a specialty occupation, the petitioner may choose to provide such evidence. Okay, what's different about that? Well, they said that you don't have to do it. You can do it, but this number 1, C1, doesn't say that if you do it, then we can ask more questions about it. So that's interesting, right? So if you show the chain of contracts and they don't think the contracts are sufficient, that they can now ask about it, where if you don't do it, they can't. But on the issue of day-to-day assignments, which is an itinerary, right? You don't have to do it. You can do it, but they don't say you can ask more if you do it. Okay, so that's interesting. And maybe that's, because a schedule is a schedule and a contract may or may not look legitimate. I think that's what they're saying there. Okay, so number 2 under non-speculative specialty occupation work. May an officer deny a petition for H-1B non-immigrant classification on the basis that the petitioner, while having identified and described the nature of the specialty occupation, has not specified the beneficiary's day-to-day assignments in a role. Okay? An officer should deny a petition when the petitioner has not established the beneficiary work in a specialty occupation. While a petitioner is not required to identify and document the beneficiary's specific day-to-day assignments, the petitioner must meet all the statutory and regular requirements, excluding the itinerary requirement. So if the officer finds the petition is not established by preponderance of evidence, statutory or regulatory eligibility for the classification, the officer should articulate that basis in denying the H-1B. So let's think about that. So while having identified and described the nature of the specialty occupation, has not specified the beneficiary's day-to-day assignments. So I guess this is it. So I think what they're saying is you need to define what the person's going to do. You just don't need an itinerary that says exactly where they're going to be doing it, right? So in your employment letter, make sure you talk about the day-to-day, duties of the job. I think that's a good idea, and I think it gets you out of any hot water there. All right, number 3, may an officer deny an H-1B extension or change of status request or revoke an approval of an H-1B non-immigrant classification if evidence in the record established that the beneficiary was benched or never worked but was still paid. Okay, so they really went into that benching's not illegal, right? It's actually anticipated as long as you get your prevailing wage, is really what those cases said. But here's what the memo says. It's a little tighter than in those cases, right? So except in certain limited circumstances, so there are limited circumstances, benching is prohibited by law to prevent foreign workers from unfair treatment by their employers and ensure the job opportunities and wages of U.S. workers are being protected. Failure to work according to the terms and conditions of the petition approval may support, among other enforcement actions, revocation of the petition approval, a finding that the beneficiary failed to maintain status or both. Okay, so if you're not working, you're out of status. That's what they're basically saying. So guidance concerning benching remains unchanged. The officer may issue a notice of intent to deny for failure to maintain status or of a notice of intent to revoke as appropriate if evidence in the record indicates there has been material change in the terms and conditions of employment, may affect liability. So lack of work may be a material change in the terms and conditions of employment that could affect eligibility of the H-1B non-immigrant classification and could require the filing of an amended petition. All right, so being benched, that means if you're not working there, that means that's a material change. You're looking at it. But they're trying to dance a little bit with the adjudication that said that it's in there. So the further regulations state that being no longer employed in a capacity specified in a petition is a basis of revocation of notice. Being placed in a non-productive status or training for an extended period of time, even if paid, may qualify as being no longer employed in capacity of specified work. If a beneficiary is in a non-productive status because of lack of work, that could indicate that the beneficiary no longer is in a specialty occupation and there has been a material change in the term of conditions of employment that may affect eligibility. However, okay, there's like, if you're not working, you're not in status. However, it would be a violation of the H-1B non-immigrant status for a beneficiary to be in a non-productive status during a period that is not subject to payment under petitioner's benefit plan or statutes such as the Family Medical Leave Act or Americans with Disability Act. So if a beneficiary has been in a working status, the officer may carefully examine the reasons and consult with a supervisor as appropriate. Okay, so they're saying FMLA, disabilities, things like that might be okay when they can look at it. But let's go further. In assessing whether the beneficiary's non-productive status constitutes a violation of the beneficiary's H-1B non-immigrant classification, the officer must assess the circumstances and time spent in non-productive status. While neither statutes nor regulations state the maximum allowable time of non-productive status, the officer may exercise his or her discretion to issue a notice of intent to deny or notice of intent to revoke to give a petitioner an opportunity to respond. If the time period of non-productive status is more than required for a reasonable transition between assignments. As always, if the officer encounters a novel issue, the officer should elevate the issue to local service center management or service center operations as appropriate. If a petitioner files an amendment or new petition reflecting the change of terms and conditions employed, the officer should not revoke the approval of the original petition unless the record establishes a pattern or practice of failure to find amended or new petition when required to do so. Instead, the officer should adjudicate the amended or new petition and may find, if warranted, that the beneficiary did not maintain status and issue a denial of the H-1B extension or change of status request, if appropriate. Ultimately, the officer's adjudication requires consideration of the time period of non-productive status, the circumstance of the non-productive status, including but not limited to medical or personal leave, and whether the petitioner filed an amended or new petition. Okay, so let's break that down a little bit. All right, so one of the big things in those ITServe cases and the others that broke in March and February of 2020 was that that while benching is not appropriate, it is not a violation to be benched. And so immigration's sort of saying, yeah, it kind of is, but we're going to try to narrowly say what's okay, right? So we agree that benching, you're not supposed to bench, but there are some limited circumstances. They're trying to define those limited circumstances here, right? So they laid out the Medical Leave Act and personal leave and stuff like that. That's not really what benching is, right? I mean, that's nearly what those companies do. So what do companies do that they're trying to stop, right? So companies will have a project, the project ends, they put somebody in another project, and for a limited period of time, they're not in that project, right? That should be okay. Immigration saying, yeah, but we're still going to nail you on that, right? And we're going to use discretion to do that. So it better be a short period of time, and you better file an amended petition. But if you file an amended petition and there was a period of time, we still may deny it, right? So there might have to go back to litigate on that one. So, the old rule of thumb of don't bench probably is what they're telling you is we're still going to look at it that way, despite what those courts said. All right. So letter D, itinerary. Should an officer continue to apply itinerary requirements under, the 8 CFR 214.2 and its progeny? USCIS will abstain from the application of itinerary requirement in the limited instance of applicable H-1B adjudications until Department of Homeland Security or USCIS issues new adjudicative or regulatory guidance on this requirement. The officer should not apply the rescinded guidance if the officer finds petition is not established by a preponderance of the evidence, eligibility for the classification under oath, statutory requirements, blah, blah, blah. Officers should continue to apply the itinerary requirement for agent-based ones. Okay, so what does that say? No, we're not going to use the itineraries. We said we're not going to use the itineraries. We settled it. But we're going to have new regulations coming out. So the executive order, maybe, for example, might bring it back just in a couple of days. So stay tuned. We'll tell you what happens on that. Letter E, limiting validity times. May an officer limit the validity period of an approved H-1B petition? USCIS may issue approvals for H-1B petitions with validity periods shorter than the time period requested by the H-1B petitioner. However, that decision must be accompanied by a brief explanation as to why the validity period has been limited. This includes, but is not limited to, instances when the certified LCA has a validity period shorter. Okay, so what does that say? Well, they told him not to do that, right? They slammed them for doing that. One of the easiest wins was when USCIS would limit these things based on itineraries and contracts. So they said, we still can do it, but one of the reasons we can do it is the LCA, but not only that. So look, a lot of this is yes, we know we settled it and we said we wouldn't do it, but we're still telling our adjudicators that they can. All right, so that's pretty interesting, right? I think, what's the tea leaves on this? We had to do it. We said we would do it. Stay tuned. We're coming hard with new regulations. That's what I read out of that. So that's interesting. Okay, that's number one. That's the memo. Big news coming down on the memo. Number two, DACA, Supreme Court case, ruled 5-4. The Chief Justice Roberts, a conservative, sided with the liberals to say that that the president, the Trump administration, improperly revoked DACA. Now, DACA, a little background on it, deferred adjudication for childhood arrivals. What does that mean? That means if a kid was brought into the country by their parents, even if their parents were illegal and they were illegal, prior to the age of 17, they could file for this deferred adjudication giving them effectively a work card and the ability to be here legally. There's about 700,000 of these folks, right? And President Trump's one of his big platforms was to get rid of DACA. And so he was struck down by the lower courts. Now he's been struck down by the Supreme Court. Now, could they start the process to do DACA again? Now, it's really interesting to look at this policy memorandum. Slammed by the courts. Policy memorandum says, well, we're still going to kind of do it anyway. We're not going to say that we're doing it, but, all those things that we said we couldn't do, other than the itineraries, we still can kind of do, right? So what do we expect this administration to do after the DACA denial? It was a political banter in 2016. It's going to be this year. Do you file a DACA right now? I don't know. It's an executive order. The president said, the deal is they just had too much hubris. He just basically said a president shouldn't be able to do DACA. He could have given a reasonable reason to do it, but chose not to. And then the court slammed him. I would steer clear of it, I think, right now. But that's to remain to be seen. Stay tuned. We'll be following that. Will there be a memo on DACA after this? Will the president say we're going to do it again? We'll see. All right, number 3, the new executive order. This should drop any day. This weekend, there will be a rally, the first major grouping of people, first major crowd other than the protests in the street, but official sort of thing in a stadium, in an arena at the BOK Center in Tulsa. I live in Norman. I am 2 hours from that in the state of Oklahoma. Is going to be the site of the first big rally. We are in the pandemic. We have been opening back up, but there's been a spike in Tulsa in particular coming out of the protests, really a lot of that. And so there's going to be a lot of people there. Probably not a lot of them wearing masks. Some will. But what's going to happen there? We think that the executive order may likely drop before so that they can talk about it in the rally. If not, it'll be early next week. Anyway, that's kind of where we are. Those are 3 things on immigration. That's a lot. Busy day on immigration today. I'm Jon Velie, CEO of OnlineVisas. Please reminding you to like and share, subscribe to our YouTube channel, turn on your notifications if you want to keep up to speed. Click some of these other cards of other visas that are similar. You might want to go back and see what our predictions were of the executive order. We got a great video on that. A lot of people tuned into that one. And then we will be dropping one just as soon as we hear that. Today, we just got this policy memorandum today. We put this out. We are not only going to talk about the executive order, we will be having a webinar likely June 25th. But stay tuned to that. Check out OnlineVisas.com for more information. Check out our Facebook and LinkedIn, Twitter, and YouTube accounts, or go to OnlineVisas.com, schedule a strategy session with us, or post some comments under this, and we'll try to get back to you. Really appreciate you. Jon Velie, CEO of OnlineVisas, delivering dreams one visa at a time.